Here's a moment that happens every single day in this country, usually over coffee or a handshake. Somebody says, put in some money with me. I'll do the work, the deal, the building, the business, and you'll get a piece of what I earn. The other person writes a check. Everybody smiles, nobody calls a lawyer. And in that moment, the moment you take a check from someone who expects a return from your efforts, you have almost certainly sold a security, whether you meant to or not. Whether it was your brother-in-law or a stranger, the law doesn't ask what you thought you were doing. It looks at what happened. Someone gave you money expecting profit from your work. Conceptually, that's the whole test. And it catches far more everyday deals than people imagine. Last episode, we talked about the business side of raising capital. Knowing your market, showing candor and rigor, removing every reason to say no. If you haven't heard it, go back. This episode is part 2 of that conversation. Because today we go underneath the business of the raise to the architecture that holds it up. The legal framework that governs every private raise in America. Now, let me be clear about what this episode is. This is not a law school course, and it definitely is not a how-to guide. It's a map. I want to give you the vocabulary and the logic, what the big statutes govern, why exemptions exist, why the identity of your investors matters so much, so that when you sit down with Securities Counsel, you can have an intelligent conversation instead of a blank stare. A map, not a manual. Because here's the truth we'll come back to all episode. Securities law doesn't care what you meant to sell, only what you sold. I'm Eddison Titus, and this is Law, Land, and Capital, where we talk about legal, business, real estate, and capital issues serious people need to understand before things go sideways. Before we go one step further, I need to slow down for a moment, longer than usual, because this topic earns it. Everything you're about to hear is general education, information only. It's not legal advice, it is not investment advice, and it is not securities advice. Listening to this show does not make me your lawyer. No attorney-client relationship is formed here. Nothing in this episode is an offer to sell or a solicitation of an offer to buy any security anywhere from anyone. I'm not directing any deal of mine, my firm's, or anyone else's. There is no deal here. This is education, full stop. And understand this about securities law specifically. It is unforgiving. It is intensely fact-specific, and it varies federally and state by state. Two raises that look identical from the outside can sit on completely different legal footing because of facts you'd never think to ask about. The rules also set specific limits and thresholds that I am deliberately not going to recite today, because those exact numbers are precisely what you sit down with a lawyer to walk through. They move, they have exceptions, and getting them secondhand from a podcast is how people get hurt. So here's the one instruction that overrides everything else in this episode. Do not raise a single dollar, not even one, without qualified securities counsel. All right. With that said clearly and on the record, let's build the map. Every map has edges. So let me tell you what's on this one and what isn't. 2 assumptions. Assumption 1, you are not a broker-dealer. What does that mean? If you're in the business of selling securities for other people, raising money for someone else's deal, especially if you're getting paid based on how much you raise, you've wandered into an entirely separate registration regime with its own rules, its own licenses, its own enforcement. That world is out of scope today. But I want to flag the classic trap because people fall into it constantly. Your buddy is raising money for his fund and he says, bring me investors and I'll cut you in on what they put in. That arrangement, compensation tied to raising money for others, is the textbook way people accidentally cross the broker-dealer line without ever knowing there was a line. I'm not telling you where the line sits in your situation. I'm telling you there is one. It's easy to cross by accident, and crossing it is a serious problem. Today's map assumes you're raising for your own venture. Assumption 2, and this is the liberating one. Real estate syndications, hedge funds, private equity, and venture capital all play by the same rules. I mean that literally. The person pooling money for apartment complexes, the person running a trading fund, the person buying companies, the person backing startups, all operating under the same federal framework. Different industries, different vocabularies, same statutes, which means something genuinely encouraging. You only have to learn this framework once. Learn the map today, and you can read the legal structure of any private raise you ever encounter as an operator or as an investor. 4 industries, 1 rule book. Master it once, and every private deal becomes readable. So where does the map start? Not where most people think. Most people walk into a lawyer's office wanting to talk about their deal, the property, the strategy, the returns. And the first question good securities counsel asked isn't about the deal at all. It's this: who will be your investors? Because investor identity determines everything that follows. Which offering paths are open to you, what your fund can look like, what disclosures you owe. Let me give you the 3 classifications that matter most. First, domestic versus international. If money is coming from outside the United States, a whole additional layer switches on. Offshore offering rules, tax structuring questions, sometimes parallel vehicles built specifically for foreign investors. I'm going to flag that layer and set it aside. Just know that the moment an overseas investor enters the picture, your attorney's job gets bigger. And so does the conversation you need to have. Second, this is the single most consequential classification in any raise: accredited versus non-accredited. Conceptually, the law draws a line around wealth, income, and financial sophistication. And it says people on one side of that line are presumed able to absorb the risk of private investments, to evaluate a deal, to lose the money without being ruined. People on the other side get more protection. Where exactly that line sits, the income figures, the net worth figures, the categories, those are precisely the numbers I'm not reciting, and precisely what your lawyer will walk you through. What you need today is the concept. Nearly every door in this framework opens or closes based on which side of that line your investors stand on. Third, the qualified purchaser. Think of this as even yet a higher tier, a substantially greater wealth threshold that, when every investor in a vehicle meets it, unlocks a different and more flexible fund structure. Hold that thought. It pays off later in the episode. Notice the theme running under all 3. The law protects investors on a sliding scale. The wealthier and more sophisticated your investors, the less the law feels it needs to protect them, and the more flexibility it hands you. The more everyday investors you have, the more processed disclosures and limitations you take on. That's not a loophole. That's a feature. In a raise, you don't pick your legal path. Your investors pick it for you. Now, the first of the 2 great statutes on this map, coming out of the stock market crash that led into the Great Depression, Congress passed the law governing the offer and sale of securities. Let me say that again. Governing the offer and sale of securities, what people usually just call the 33 Act. Keep those 2 words in mind, offer and sale. This statute governs the transaction. The moment you ask someone for money, the disclosures you make, the moment money actually changes hands. And its default rule is sweeping. Every offering of securities must be registered with the federal securities regulator. Registration means the full public offering apparatus. Armies of lawyers, audited disclosures, review, enormous cost. The machinery behind every company on a stock exchange. Obviously, the person raising money for a duplex or a small fund can't run that machinery. So the law provides exemptions, specific, defined situations where you may offer and sell securities without registering. And here's the thing to understand about private capital. Private raises don't live near the exemptions or alongside the exemptions. They live entirely inside them. That's why you'll hear the phrase exempt offering constantly in this world. Every syndication, every private fund, every venture round you've ever heard of was built on somebody qualifying for an exemption. Deliberately, carefully, with counsel checking every single box. But there's one more piece, and it might be the most important sentence in this episode. The anti-fraud provisions of the securities law apply to every offering, registered or exempt, big or small, family money or institutional money. An exemption excuses you from the registration process. It never excuses you from telling the truth. Misstate a material fact, omit something an investor needed to know, dress up the numbers, and no exemption on earth will protect you. Think of a composite character, let's call him Dominic. Dominic raises money from friends for a self-storage project and rounds his experience up from helped on a few deals to seasoned operator. Dominic may have qualified for a perfectly good exemption. It will not matter. The exemption covered his paperwork, not his honesty. You can be exempt from registration. You were never exempt from telling the truth. Statute number 2. A few years after Congress addressed the offer and sale of securities, it passed a second law aimed at something different. The vehicle. What people usually call the 40 Act governs pooled investment entities. And it starts from a startling premise. If you pool other people's money in order to invest it, you may be an investment company in the eyes of the law. The same category as a mutual fund and subject to mutual fund style regulation, boards, restrictions, compliance, infrastructure, the works. For a private fund, that's not survivable. So, same pattern as before. Private funds survive by fitting an exemption. There are a handful of defined exits from investment company status, and which one of your vehicles fits determines its fundamental shape, how many investors it can have, and who those investors must be. We will walk those structures in a few minutes. But first, lock in the distinction between the two statutes, because this is the load-bearing wall of the whole map. The 33 Act and the 40 Act answer different questions. The 33 Act asks, how may you offer and sell this investment? What's the transaction? What's the disclosure? The 40 Act asks, what may your entity be? Is this pool of money a regulated investment company, or does it fit an exemption? How you sell versus what you are. 2 statutes, 2 questions, and a compliant raise threads both needles at once. Picture a composite operator, let's call her Amara, raising a small fund to buy industrial properties. Her counsel isn't doing one analysis, she's doing 2 in parallel. 1, which exemption covers how Amara offers and sells the fund interests? 2, which exemption keeps Amara's fund from being an investment company? Get either one wrong, and the whole structure fails. That's why this work is never do it yourself. The 33 Act watches the sale. The 40 Act watches the vehicle. You answer to both. All right, let's open up the first menu, the offering paths. The main exemption routes under the 33 Act for how you may offer and sell. There are 5 you'll hear about constantly. I'll describe each at the map level. What kind of road it is, who it's built for, and the rule name each one goes by so you recognize it when your lawyer says it. What I'm deliberately not reciting are the dollar caps and investor limits attached to them. Those numbers are exactly what you walk through with counsel. Path 1. The small offering path, what the rules call Rule 504 of Regulation D, built for modest raises. There's a cap on how much you can bring in with a lighter federal compliance load. The catch, when the federal layer gets lighter, the state layer gets heavier. Every state has its own securities laws. The old term is blue sky laws. And on this path, they loom large. Raise from investors in several states, and you may owe compliance in each and every one. Path 2, the workhorse of private capital, Rule 506B of Regulation D. The overwhelming majority of syndications and private raises travel this road. No cap on the amount that you can raise. Your investors must be accredited, plus, in limited numbers, non-accredited investors who are financially sophisticated. But here's the defining restriction. No general solicitation. No advertising, no social media posts about the deal, no pitching from a stage to strangers. You raise from people you have a pre-existing substantive relationship with. This is why serious capital raisers build their networks for years before they build their deals. Path 3, the advertising path, Rule 506C. This one flips the trade. You may solicit generally, advertise the offering to the world. In exchange, every single investor must be accredited. And you can't just take their word for it. You must take reasonable steps to verify their status. Documentation, third-party confirmation, real diligence. Advertise freely, verify rigorously. Path 4, what practitioners call the mini IPO. Formerly Regulation A, or you'll hear Reg A+, especially for its larger tier. A scaled-down public-style offering. You prepare an offering document that the federal regulator actually reviews. You operate under tiered caps on the raise. In exchange, you reach non-accredited investors at real scale. It's a genuine middle road between private and public, and it carries genuine cost and genuine time. Nobody wanders on to this path casually. Path 5, crowdfunding, regulation crowdfunding, or Reg CF. Raising from the general public through a registered online portal. The smallest ceiling on the raise, the broadest possible audience, and the most prescribed box-checked process of all 5. Now, step back and see the pattern, because it's the same bargain running through all 5 paths. And once you see it, you can never unsee it. Audience reach versus compliance burden. The road that lets you talk only to people you already know asks the least of you. The road that lets you reach the whole world asks the most. Every offering path is the same bargain. The more people you can reach, the more process you owe. Menu number 2, the fund structures. The 40 Act side of the house. Remember the question that this statute asks. What may your entity be? If you're pooling money, your vehicle needs an exemption from investment company status. And there are 3 you'll hear about again and again. Same ground rule as before. Plain English names plus the exemption each one goes by, but no counts or thresholds. Structure 1, the classic private fund. The exemption Counsel will call 3C1. This is the standard small fund exemption, and its defining feature is a headcount cap, a limit on the number of people who can beneficially own the fund. Most first funds, most club deals, most small syndicated vehicles live here. The cap is a real, specific number, and your counsel will give it to you. And just as important, explain how it's actually counted, because counting beneficial owners is trickier than it sounds. Structure 2, the Qualified Purchaser Fund, known as 3C7. You remember that higher wealth tier I asked you to hold on to? Here's the payoff. If every investor in the vehicle meets the qualified purchaser threshold, the headcount cap effectively falls away. You can scale the investor base dramatically. The trade is the tier itself. a much smaller universe of eligible investors, each far wealthier. This is the structure behind many large hedge funds and institutional vehicles. Structure 3, and if you're in real estate, lean in, the real estate exemption, what the trade calls 3C, 5C. There's a specific exemption for vehicles primarily holding mortgages and interests in real estate. Fit it, and your fund can sit outside the headcount caps entirely. This is a big part of why real estate funds can look structurally different from other private funds. Why some grow investor bases that a classic private fund never could. Whether your vehicle actually fits what generally counts as qualifying real estate interest is a technical, fact-driven analysis. Map level. The exemption exists, it's powerful, and it's one of real estate's quiet structural advantages. And notice, third time now, the same pattern. Richer, more sophisticated money means fewer structural constraints. Sliding scale protection all the way down. One more thing before we leave this menu, and it may be the most practical insight in the episode. The offering path and the fund structure are not chosen separately. When Counsel designs a raise, the 33 Act path and the 40 Act structure are engineered together because each constrains the other. Who may you solicit shapes who can own the vehicle, and who owns the vehicle shapes how you may solicit. It's one architecture drawn across two statutes. Anyone who talks about their exemption in the singular probably hasn't understood their own deal. The offering and the vehicle aren't two decisions. They're one architecture drawn in two statutes. One special vehicle before we land this, because if you're around real estate capital, you hear the word constantly. The REIT, the Real Estate Investment Trust. And here's the reframe most people need. A REIT is not a kind of deal, and it's not really a securities law creature at all. A REIT is a tax construct, a status layered on top of a real estate vehicle. Conceptually, the tax code makes an offer. Structure your entity so that it passes a series of tests, asset tests about what you hold, income tests about where your revenue comes from, and distribution tests about paying income out, and the entity largely escapes tax at the entity level. Income flows to the shareholders without the corporate level bite. That's the entire appeal, and it's enormous. The signature obligation is the distribution requirement. A REIT must pay out the bulk of its taxable income to shareholders every single year. That's why REITs are known as income vehicles. The distributions aren't generosity, they're the price of the tax status. Now, REITs come in public and private flavors. You can buy shares of the public ones on an exchange. But here's the map placement point people miss. A private REIT still needs a securities law home. REIT status answers the tax question and only the tax question. A private REIT raising money still needs a 33 Act exemption for how its shares are offered and sold, and its vehicle still has to resolve its 40 Act status. Everything we built this episode still applies. The REIT wrapper just sits on top. So the full stack for a real estate vehicle reads like this. The 33 Act governs how you sell it. The 40 Act exemptions govern what vehicle it is, and REIT status governs how it's taxed. 3 layers, 3 different questions. A REIT is not a kind of deal. It's a tax deal the IRS makes with a real estate vehicle that follows its rules. Let's rebuild the entire map in about 60 seconds. It starts first with who. Who are your investors, domestic, international, accredited or not, qualified purchasers or not? That answer is the master variable. It opens some doors and seals others before you've said a word about your deal. Then how? The 33 Act governs the offer and sale. Everything must be registered unless exempt. The private raises live entirely in the exemptions. 5 main paths, each striking the same bargain between how many people you can reach and how much process you owe. Then the what. The 40 Act governs the vehicle, and your pooled entity survives by fitting an exemption. The classic capped fund, the qualified purchaser fund, or the real estate exemption, with the offering path and the structure engineered together as one architecture. And sometimes, on top of it all, a REIT wrapper, a tax status with its own tests and its own obligations, sitting on a vehicle that still answers to everything underneath. One framework: real estate, hedge funds, private equity, venture capital, all of it. So 3 takeaways to carry out for here. 1. Investor identity is the master variable. In a raise, your investors pick your legal path for you. 2. Exemptions are the game, but anti-fraud is forever. You can be exempt from registration and never exempt from the truth. 3. And this is the whole spirit of the episode. This map exists so you can hire securities counsel intelligently and talk with them productively. It is not a substitute for hiring them. Before you take $1, before you so much as make the ask, get securities counsel in the room. Know the map well enough to hire the guide, and never confuse the map for the territory. That's the legal side of raising capital. And together with last episode, you now have both halves of the raise. The business that earns the yes and the architecture that makes the yes legal. Next time on Law, Land, and Capital, why operators and investors misunderstand each other. The 2 mindsets on opposite sides of every deal and how to translate between them. If this map made a murky subject readable, do 3 things: like, follow, subscribe. And share this 2-part series with someone who's talking about raising money before they take a check. And if you need a consultation or a referral, call the Titus Law Firm. This program is owned and produced by Tadamco LLC. All rights reserved. I'm Eddison Titus. Thanks for listening. And remember, securities law doesn't care what you meant to sell, only what you sold.